Now back to the show. This is The Law Show on CL 650.
You knew that one was coming. Producer Dwayne Bishop with a little help from Jackson Brown. Lawyers in Love. Welcome back to The Law Show here on CIL 650. Our guests in studio, John Lakes and John White, partners at Lakes White LP, a North Vancouver law firm. Always pleasure to have these two gentlemen in studio as we talk about wills and estates. And on the program today, zooming in on spouses and with a little bit of luck later on, children. And if not, we'll just dedicate a whole show to that. And John White, the whole matter of children, really, you could do hours on fights in court over estate matters involving the children of the deceased, couldn't you?
Oh, you sure could. I mean, so many of these cases involve children who are unhappy with what happened in their parents' wills. That's what keeps us busy half the time.
I'm sure it is. But we're focusing first and foremost, John Lakes, on spouses. And you had some very provocative words a few minutes ago about people in common law relationships. You actually had a bit of a warning because it all deals with status in after the death of your partner in law, and some status may be lacking for some common law partners.
Well, it's quite different because if you're legally married to somebody when they die, that person has an obligation to you until either you have a divorce or else you have a declaration made in Part 5 under the Family Law Act, which of course can be subject to litigation and so forth. So nobody can take your rights away from you overnight.
Right.
The problem is under WESA, it says in the case of a marriage-like relationship, one or both persons can terminate the relationship. And so particularly when you get to elderly people, you could have one person in the care home who's totally incompetent, who has no ability to fight anything, who may not even know that their spouse has gone to a lawyer or notary and signed a declaration saying, I no longer live with Margaret, she's no longer my spouse.
Right.
And when that person dies, all his heirs have to do is produce this document, and Margaret has no rights, even if she's been with him for 40 years. And it's totally unfair, and there hasn't been any cases on it yet, and I'm quite shocked because when this legislation was passed, it was one of these legislation was passed in Victoria with virtually no debate, and they all voted for it.
Right.
And I've talked to some MLAs, and Jane Thorntwaite's been very helpful, who's the MLA from North Vancouver, but nobody else has. So,
right.
So I sometimes feel like I'm shouting in the wind.
But in the absence of constructive assistance by government, the legislature, etc., there are some people who could be in jeopardy legally, who have been in long-term common law relationships.
Well, it could be, and I'm not a litigator. John can speak for it, but there could be some case that will come up where the court may say this is so unfair that all of a sudden they strike out paragraph 2B, because you could have people in a common law relationship for 40 years, but for various reasons the house is in the husband's name.
Yes, yeah.
And to think that the wife could get nothing is... We go back to the whole issue of common constructive trust. But John, maybe that's a case John will get to do one day and get this provision of the Act struck out, because I think it's totally unfair.
Well, I got to tell you, John's looking pretty keen to get out a case just like that. But in the absence of one on your desk at the moment, you have brought a couple of representative examples of recent decisions in British Columbia wills and estates law. Tell us about some of these cases.
Well, what we've been looking at are the cases where the court is called upon to determine whether the plaintiff, the person bringing the case, was or was not the spouse, the common law spouse of the deceased person. And it's interesting to see what the courts look at both before and now after WESA, the new legislation, has come in.
Right, and WESA, friends, stands for Wills, Estates, Succession Act. It's the new one in BC, less than about a year and a half old now.
Yeah, almost exactly.
Yeah. Okay, so the first of these cases involves Richardson and Richardson. So when you get some of these, there are a number of plaintiffs
right.
and people listed. So tell us about the Richardson case.
Well, this is a case starring, it would seem, half the population of Gambier Island. It's a case that largely depends upon what occurred there and what people saw there, but there was a common law couple who maintained 2 residences, one in Gambier and one off island. And the question the court had to deal with was, despite having those 2 residences, were they common law spouses? What the court is trying to do, and I think what the court tries to do in every case like this, really is to determine what the intentions were of the 2 people who are said to have been spouses.
Right.
That is, did they believe themselves to be a married couple or not, even though they weren't legally married?
And this is where your job gets weird and tough all at once, because half of that group is dead.
Well,
the most important witness in your case is deceased.
And that's a huge problem. That's the fundamental problem every time you're bringing a case that involves a will. The number one person you'd love to talk to find out what really happened isn't there to talk to you.
Exactly.
And that's the problem when you're looking at these wills cases through the rearview mirror. You're trying to reconstruct what most probably happened, or what people's intentions most probably are.
So in this case where there were 2 residences involved, John White, were they actually married or were they common law, the principals?
Well, cutting to the end of the story first, not to keep you in suspense.
Oh, you love it.
The court found at the end of the day that the two people were very much a couple. They very much believed themselves to be a common law couple, or really a married couple. They intended to be a married couple. But what the court looked at to get there is a whole host of factors about how these people lived their lives and what the evidence was as to how they lived their lives.
Okay.
So the court's going to look at things like, and the court did look at things like shelter. Where did they live? Did they live under the same roof? Sleeping arrangements. They looked at personal and sexual behavior. They looked at just the day-to-day provision of services mutually, things like preparing meals, washing clothes, shopping, just the things that we all do every day.
Right.
The court looked at how these 2 people fulfilled those functions. They looked at what they or how they appeared in public socially, whether they socialized as a couple, for example.
Okay.
They looked at what the society around them thought of their relationship.
Were there children involved?
In this case, I would have to remind myself whether there were children involved in this case, but whether there are children involved, or what the parties think about children.
That's what
what their intentions are, whether they have any particular common attitude and conduct concerning children, whether or not there are actual children involved. That's a factor the court will think about. Financial factors, obviously.
Of course. That's usually what the fight is about, isn't it, John?
Well, a lot of these fights come down to money. But really, these are all just ways that the court can approach the question of what the intention of the parties were. This isn't a checklist. It's nothing like that. It's just a tool that the court can use to assist it in coming to determining the real question, which is, what do these people intend, even though one of them is now no longer with us and the other one has an obvious interest in one particular answer to that question.
But what was the case? Why was the case brought forward in the first place? Well, one person is clearly deceased. The other person, the spouse, the remaining spouse, brought the case forward. Why? Because was there in the will? Were they left out or something, John? Is that why the thing ended up in court?
Well, in this case, there's always another actor in these cases. There's always, you need 2 people to make a dispute in almost all cases. And in this case, the deceased had a brother who contested that the spouse, the person found to be the spouse, really was the common law spouse. And the answer to that question had a big effect on who would be first in line to inherit from the deceased.
So the
gentleman.
brother, if the brother could convince the court to declare the spouse to be not so, then he would be first in line for all the goodies, wouldn't he?
I just want to clarify, there was no will there.
Okay.
Yes.
So there is no will, so if someone dies with a will, it goes according to administration. and the beneficiary is the first person in line. So if there was a spouse, that person would be basically get the estate.
That's an automatic, isn't it?
Because the person had no children.
Okay.
And if there was no spouse, it would go to his parents, and he had no parents. They were both deceased. So it was his brother who contested it. So it was a battle between the brother. It was in his best interest saying they were not a common law spouse, because if he was successful, he got everything.
Right, but the nature of the case and the whole reason it went to trial is the absence of a will. There was nothing written down, and so you had to sort of backtrack through all of this, right?
That's the problem, is you're trying to reconstruct what happened in the past and what people intended in the past when you don't have those people to talk to anymore.
Right.
You can't ask them.
Right. And John Lakes, just as an aside, because we're talking about spouses and common law and this, that, and the other thing, I would assume in the fall of 2015, we're talking about same-sex couples as much as common law couples, as much as married couples, correct?
Yes, and they have the same rights as anybody else does.
Just thought I should ask that, just for
that
clarification.
was decided about 10 years ago. So again, they have it's a spouse, and that's doesn't matter.
Okay. And in the case of the Richardson outcome, John White, the court found that she was indeed a spouse, filled all the definitions and all the rest of it. So the brother, who was standing to be first in line, didn't end up there. He ended up where I'm sure the spouse wanted him, which was somewhere behind her in the line, right?
Yeah. I mean, essentially the court found that Mr. Richardson and the plaintiff in this case had a loving and intimate relationship for more than 2 years, and in fact for considerably more than 2 years.
Right.
There were two residences here, but it was really for work purposes. I think importantly, at least from the way I read this case, is that the court found that Mr. Richardson thought that his spouse was in fact his spouse, and in the sense of someone who needed to be taken care of afterwards. In other words, the court made a finding as to what his intention was, even though he was no longer there to tell the court what his intention was. And the court got there by looking at all of the evidence from all kinds of people, and looking at some of the factors that I stated earlier, and coming to the best decision it could on the evidence before it.
We need to take a break, but John Lakes, just before we do, is it your experience that couples who are common law are a little more casual also about the formality of drawing up a will?
Well, sometimes they are, because they think being common law is the same as being married.
Right.
And then some people hide their relationship too for various reasons, which, I have friends of mine, they lived together for 2 years before their parents knew, because there was quite a religion in the family. And it used to be that when you wanted to phone them, if the guy wasn't there, you had to ring twice.
Right. Hang up
and phone again. Now, of course, with texting, you don't have that same issue. But, sometimes for various reasons, and sometimes particularly with same-sex couples, sometimes they want to hide it from their family members, or because of some religious pressure or other things. So it's a real issue. And
so coming forward and drawing up a will is perhaps a little too out there for people who are...
And John will take another case to talk about another case, because sometimes one person thinks they're in a common law relationship, and the other person doesn't think that. They just think they date a lot.
Oh, really?
With overnight privileges.
Oh, man. Oh, well, we'll get to that. Let's take a break here, Dwayne, and that way we can, when we get to this next case, and it sounds quite interesting to say the very least, we'll have time. We'll let John White just walk us right through it. This is The Law Show. Our guests, John Lakes and John White. The firm is Lakes White LLP in North Vancouver, and they're online at lakeswhite.com. Lakes White is Lakes. White is Whyte. LakesWhite.com. Have a look while we take a quick timeout.
There's more of the show still ahead. This is The Law Show on CL 650.